This is docket 5 EI 160, the Infrastructure Investment and Jobs Act, consideration and determination pursuant to 16 U.S.C. section 2621. This is Michael Newmark, the administrative law judge for the PSC, and we're here with a public hearing to receive comments from the public on this docket. We can do that live here today at the hearing. We're also in the process of taking written comments, and those are due no later than Tuesday, September 5th, by either the Commission's website or by U.S. mail. Details to do that is in the notice of hearing, and that's being displayed here on the screen share and also posted on the Commission's website. I haven't actually checked. I don't think we had any comments. No comments at this time yet in writing. So we'll wait to see those come in. But at this point, I know we have a number of people joining us from outside the agency. We also have Commission staff connected. This is just a public hearing, so we won't take appearances for people who have joined us. But we'll have a statement from staff first, and then we'll open up the hearing for public comments. I'll just do my best to kind of take people as I've seen them join us, since there's not many at this point, but I'll do my best. So I'm going to turn off the screen share. I don't think we really need that the whole time. And I know staff was interested in making a statement, so I'll have Attorney Kuntz call our witness.
Jennifer and Brian will make a statement regarding the requirements under 16 U.S.C. 2621.
Okay,
Related.
Let me swear you in.
Okay.
Raise your right hand. For
Jennifer. Jennifer. I was like.
And do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Okay. All right. So continue on, Attorney Kuntz.
She'll provide a statement regarding the requirements for demand response and EV charging programs under this under the Infrastructure Act, Investment Jobs Act.
Okay, thanks. Sorry, didn't realize I was cutting you off there. Okay, so is it time for the statement? Do you want to go ahead with that?
Sure. Thank you very much. I just have an opening statement. It is a little bit long, so I appreciate your patience. This public hearing on docket 5 EI 160 addresses consideration and determination of standards related to demand response and electric vehicles. The Infrastructure Investment and Jobs Act of 2022, also known as the Bipartisan Infrastructure Law, enacted November 16th, 2021, modified the Public Utility Regulatory Policies Act by requiring that the Commission make a determination concerning whether it is appropriate to implement utility demand response requirements and electric vehicle charging programs under 16 U.S.C. section 2621, subsection D, 20 and 21. Prior to making the determination, the Commission must hold a public hearing pursuant to 16 U.S.C. section 1622, subsection B, 7 and 8. This hearing will review the work the Commission has and is undertaking in the areas of utility demand response and electric vehicle charging programs. The Commission took interim action on demand response in docket 5 UI 116 and has an open investigation in docket 5 EI 158 investigating several issues, including demand response. The Commission also investigated electric vehicle charging programs in docket 5 EI 156 and implemented electric vehicle charging programs in subsequent utility tariff dockets. The Commission opened docket 5 UI 116 in March 2008 to investigate electric and natural gas rate designs and load management options in accordance with the Governor's Task Force on Global Warming recommendations. On February 19th, 2008, the Governor's Task Force on Global Warming issued its interim report, A Wisconsin Strategy for Reducing Global Warming. The task force recommended that the Commission investigate and adopt innovative rate designs that provide more accurate price signals to customers to incent reduction of greenhouse gas emissions associated with their energy consumption. The task force also recommended the development of load management programs that would, quote, enable customers to reduce their contributions to utility peak demand, thereby lessening greenhouse gas emissions, end quote. As part of its examination of demand response activities, the Commission investigated and addressed FERC Order 719, which, among other requirements, required that the Commission examine the participation of aggregators of retail customers in wholesale markets. In Order 719, FERC found that allowing aggregators of retail customers to participate in wholesale markets would reduce barriers to demand response, expand the development of demand response resources, and increase competition, thereby reducing prices and enhancing reliability. Order 719 provided that a regional transmission organization must allow bids into its markets, quote, unless the laws or regulations of the relevant electric retail regulatory authority do not permit a retail customer to participate, end quote. In an October 14th, 2009 order directed to 4 specifically named public utilities, Northern States Power Company, Wisconsin, Wisconsin Power and Light Company, Wisconsin Electric Power Company, and Wisconsin Public Service Corporation, the Commission imposed as condition on their provision of electric service that these named utilities be prohibited from transferring the demand response load reductions of retail customers to MISO markets directly by retail customers or by third-party aggregators of retail customers. This temporary order was issued in order to prevent potential unlawful discrimination and to permit the Commission additional time to gather more information regarding aggregators of retail customers. The 2009 order issued in docket 5 UI 116 continues in effect until rescinded in whole or in part by further Commission order. In a memo dated February 16th, 2011, the Commission determined that instead of establishing a prescriptive task list that utilities would follow in the development of demand response programs, the docket would be an opportunity for Wisconsin to assess its demand response programs and the potential that may exist to expand programs in an economical fashion. The docket also provided an opportunity to review early feedback on demand response pilot programs that were initiated by Wisconsin Public Service Corporation as part of its 2008 rate case. On April 15th, 2011, the University of Wisconsin's Energy Analysis and Policy Graduate Program, part of the Nelson Institute for Environmental Studies, presented a study to the Commission on Wisconsin utilities' current and potential demand response programs. The Commission did not take any additional action on this docket. However, utilities have continued to include demand response programs in their tariffs. The Commission opened docket 5 EI 158, a roadmap to zero carbon, in March 2021 to consider the ongoing transition to zero carbon electricity generation in Wisconsin. The Commission opened this investigation to obtain further information on ongoing changes in Wisconsin's electricity sector and economic and environmental considerations that are contributing to increased deployment of zero carbon technologies for meeting customers' electricity needs. This ongoing investigation is analyzing the full range of considerations and identifying approaches to achieve the economic and environmental benefits the transition can provide while maintaining adequate electric supply, reliability, and affordability for all customers. As part of the investigation, the Commission is investigating utility demand-side management programs including demand response, and potential and performance-based rate making, including possible performance incentive measures related to demand response. Any order issued in docket 5 EI 158 relating to demand response and aggregators of retail customers would supersede any order of the commission in docket 5 UI 116. The Infrastructure Investment and Jobs Act also required each state to consider measures to promote greater electrification of the transportation sector, including the establishment of rates that A, promote affordable and equitable electric vehicle charging options for residential, commercial, and public electric vehicle charging infrastructure. B, improve the customer experience associated with electric vehicle charging, including by reducing charging times for light, medium, and heavy-duty vehicles. C, accelerate third-party investment in electric vehicle charging for light, medium, and heavy-duty vehicles. And D, appropriately recover the marginal cost of delivering electricity to electric vehicles and electric vehicle charging infrastructure. The commission opened docket 5 EI 156, an investigation into electric vehicles, on February 21st, 2019. The commission's investigation encompassed a number of policy and regulatory considerations, including but not limited to the following items. 1, customer expectations regarding electric vehicles in general, including availability of electric vehicles and access to charging stations for electric vehicles. 2, customer expectations of electric utilities regarding electric vehicles. 3, policies and standards of electric utilities regarding electric vehicle infrastructure. 4, ownership and operation of electric vehicle infrastructure and related legal issues as applied to established electric utilities, possible public and private intermediaries, or developers and ultimate consumers. 5, financing and cost recovery of electric utilities, electric vehicle capital investments. 6, rate design and service considerations of electric utilities, electric vehicle tariffs. 7, electric vehicle impacts on electric storage, distribution, transmission, and generation infrastructure. And 8, electric vehicle impacts on intrastate and interstate competition, given different state regulations applied to electric infrastructure and pricing and cost recovery. The investigation included 2 rounds of public comment, a workshop, public comment on a draft order, and a final order. Commission staff also participates on the State of Wisconsin's Electric Vehicle Infrastructure Steering Committee. The Commission's final order dated December 22nd, 2020 in docket 5 EI 156 encouraged utilities to propose residential electric vehicle programs to address one or more of the following aspects of charging service for residential customers: rates related to electric vehicle charging, load management efforts to control the timing of charging, and/or initiatives to address the upfront purchase costs of electric vehicles and residential charging technology to potential owners. The Commission has since approved several residential electric vehicle charging pilot programs under utility tariff dockets, including multi-residential electric vehicle charging pilot programs in the following dockets: 3270-TE-115, 4220-TE-104, 4220-TE-113, 6630-TE-106, and 6690-TE-111. In this hearing, the Commission is soliciting public input on whether it is appropriate to continue to implement utility demand response requirements and electric vehicle programs in current or future dockets. Thank you for your attendance in this hearing. This concludes my comments.
Okay, well, thanks very much. All right, well, we can open up the hearing now to public comments. I do see two members of the public, looks like they're representing Wisconsin Power and Light. So either one wish to comment, just let me know.
No need to comment, Your Honor, just monitoring the docket. Appreciate the time.
Okay, thank you. All right, so we don't see any other members of the public in attendance. And it's already 17 after 10. So at this point, I think we have provided time for people to join us in order to make a live comment. And we can expect, if we do receive comments, we'll expect those in writing. Like I mentioned before, those are due Tuesday, September 5th, either through the commission's website or by U.S. mail. So at this point, thanks everyone for joining us, and hopefully you had some people listening in, watching in. You could always also view the recording on YouTube. So at this point, I think that's all we can do. And thanks very much, everyone. We're adjourned.